Our distinguished lecturer today is a gentleman who didn't like law school much when he was a law student, I read, but who's gone on to become not only a gifted constitutional law advocate, but an award-winning teacher at the University of Chicago Law School, one of our country's foremost scholars in constitutional law in the Supreme Court, and a fellow of the American Academy of Arts and Sciences on top of all of that. David Strauss did his undergraduate studies at Harvard College, where he graduated summa cum laude. He studied politics at Oxford on a Marshall Scholarship, after which he returned to Harvard and its law school, where he took his JD degree magna cum laude and served as an editor on the Law Review. He went on to several impressive assignments for any young lawyer. He served as a law clerk to Judge Irving Goldberg on the Fifth Circuit Court of Appeals, and then entered government practice, first as an attorney advisor in the Department of Justice's Office of Legal Counsel, and then as an assistant to the Solicitor General of the United States. By the time he had reached the ripe old age of 30, he'd already had 2 arguments before the U.S. Supreme Court under his belt. Now, since 1985, Professor Strauss has been a member of the faculty at the University of Chicago's Law School, where he now serves as the Gerald Ratner Distinguished Service Professor of Law. An acclaimed teacher, he's also a prolific scholar with influential contributions on judicial review, constitutional interpretation, affirmative action, abortion, racial discrimination, and freedom of expression, to name just some of the topics he has addressed. He's a co-editor of the Supreme Court Review, the prestigious annual journal that since its inception has published some of the most important articles on the court and its work in interpreting the Constitution. And in 2010, the Oxford University Press published The Living Constitution, Professor Strauss's book-length treatment of themes that have animated so much of his work through the years. All along, Professor Strauss also has kept a strong and effective hand on law in the real world. He's testified before Congress on many occasions, and in 1990 served as special counsel to the Senate Judiciary Committee. He counseled President Clinton in litigation, and over the years has argued 18 cases before the United States Supreme Court. He served locally as well as chair of the Board of Trustees of the University of Chicago Laboratory Schools, and as a member of the Board of Governors of the Chicago Council of Lawyers. For Professor Strauss, the American Constitution is not simply or merely a document, a text, but it's also a set of institutions and principles that our nation has built through generations of experience. Or as he has said, the consequences of a series of hard-fought battles rather than the product of a single inspired stroke of the pen. His topic today invites us to consider the implications of that view in assessing a very real and practical constitutional controversy in the here and now. A recent decision of the U.S. Court of Appeals for the D.C. Circuit has cut back sharply on the president's power to make appointments when the Senate is not in session. As the justices of the Supreme Court take up the matter this year and address the constitutional metes and bounds of so-called recess appointments, what significance, if any, should attach to the historical practices of our presidents? American presidents in the modern era have asserted their authority to make appointments without the advice and consent of the Senate when the Senate is not in session. What weight in constitutional adjudication should those claims of presidential authority bear? Ladies and gentlemen, draw near and find out. Please join me in warmly welcoming Professor David Strauss.
Thank you so much. That's so great. Thank you. Thank you very much, Dean Bilionis, for that very gracious and generous introduction, and thank you all for coming. My subject is constitutional fundamentalism and the power of the president, and I want to talk about recess appointments. That's a lot of big words, so let me just kind of make it a little bit more concrete for you. Of course, this lecture is in honor of that guy, who, as Dean Bilionis said, is the only person in history to have served both as President of the United States and as Chief Justice of the United States, as well as being a graduate of this law school, the Dean of Law School, and a transformational figure in the extraordinary history of this great school. My subject really covers both branches of William Howard Taft's career. It's a question about executive power, the power of the president, as Dean Bilionis said, to make appointments under certain circumstances, appointments to executive office positions. But it's also a topic that touches on the role of the Supreme Court and exactly what the Supreme Court should be doing when it's interpreting the Constitution. The case that Dean Bilionis mentioned is a case before the Supreme Court now, possibly the most important case the Supreme Court will decide this year. It's a case about this previously obscure clause in the Constitution called the Recess Appointments Clause, but it's a case that raises very basic questions about the nature of our Constitution, the nature of constitutional law, and the role of the courts in the American system. And it's a case that really invites us to think about some issues about just what it means to talk about the U.S. Constitution and how it should be interpreted. Let me sort of first talk about what I mean by constitutional fundamentalism before I actually get into the substance of this case. And here's the basic idea that the sort of core idea of fundamentalism, as I'm using the term, is, if you have a question about the Constitution, you go back to the text. You go back to the text of the Constitution. That's what you should be looking at. And all other considerations are secondary or maybe even irrelevant to the text of the Constitution. Now you might think, well, of course. I mean, that's the Constitution, isn't it? Of course you look at the text of the Constitution. I want to say not so fast. In fact, maybe I want to say quite not at all. That would be crazy. But I do want to say that the text of the Constitution, while obviously important, obviously critical, is by no means the whole story. And that's the position I want to present to you today. So what else is there besides the text of the Constitution? Well, here's the idea. It's a long quotation, but let me just sort of hit the highlights for you. It's a quotation from Edmund Burke, because you know, great British statesman, a classic conservative, small c conservative thinker, because I think these questions about the nature of constitutional law, I don't think they line up with what we think of as partisan divides in American politics. I think they are on a different dimension. And you find some of the best accounts of the position that I want to advance in thinkers of various kinds, including a thinker who, as I said, is identified with the conservative tradition. But here's what Burke had to say about this subject. When he said, look, if you're talking about what goes on in a country, what a country's governing ideas are, it's not just, as he says, it's not a choice only of one day or one set of people. Now, he's not talking about the framing of the Constitution, but he is talking in general terms about how countries figure out what law should govern them. And he says it's not a choice of one day or one set of people. It takes place over generations. And it responds to particular circumstances and things that are going on in the society and the way the moral code of the society changes and the habits of a society change. And that takes a while for people to discover. And they learn and they build on what's gone before. And he makes this nice analogy in the last sentence I have quoted there to a vestment, which is clothing, but he's writing in 1782. He's going to say vestment, right? Because that's the way people talked back then. It accommodates itself to the body. And the Constitution is something that changes shape over time and accommodates itself to what we are, rather than our trying to accommodate ourselves to something that was laid down in 1789, when the Constitution was ratified. So that's what I see the underlying debate in the recess appointments case as being. And I'll get into the particulars of that case. But I think the big picture view of that case is something like this, that the problem with the District of Columbia Circuit opinion that Dean Bilionis described, the problem is that it fails to recognize that in the 200 plus years since the Constitution was ratified, we've worked out ways of doing things. We figured some stuff out. Figured it out, within the broad framework of the Constitution, but it's not all there. It wasn't all there at the beginning. The framers couldn't have expected it to be all there at the beginning. They understood they hadn't thought of a lot of things. And that it's a mistake, really a mistake, to sweep aside all the things we've worked out in the intervening 200 years and try to go back to the text. That's a mistake. Try to go back to what they wrote down then, or more precisely to what people today think they wrote down back then. That's the mistake I want to get at. Now, what's interesting and significant about this case before the Supreme Court about recess appointments is the sort of fundamentalist talk is very common in American constitutional law. People are always talking about the framers and James Madison and what they would have wanted, and there's no problem with that. a perfectly fine way to talk about American constitutionalism. But while people talk that way, it's pretty unusual to see a court actually try to implement that, what I'm calling fundamentalist vision, and actually say, well, we're going to decide this case strictly on the basis of what the words say, and with minimal attention being paid to what's developed since then. You don't see that happen very often, because I think, in fact, our system is one that acknowledges Burke's point that these are practices and habits and understandings and traditions that have developed over time. I think that is our system. So it's rare to see a court say, no, we don't care about that, or to be fair to the DC Circuit, it didn't say we don't care about it, but it de-emphasized it greatly and said, let's look at the text. And so it's really a test of, this case will be, among other things, potentially at least, a test of which vision of the Constitution is going to prevail. Okay, let me talk about the case. The case is a little bit intricate. It involves focusing on the text, as you for reasons that you can see by now, thanks to Dean Bilionis' introduction. So let me just do the text, and then we can get into some of the bigger questions. You know what this says. This says that when the president wants to make an appointment to an executive branch position, or a judge or an ambassador or something like that, ordinarily the appointment has to be confirmed by the Senate. That's the usual rule. The recess appointments clause says this, and the basic idea, the language turns out to be critical, as for reasons I said, but the basic idea of the recess appointments clause goes like this. Okay, the Senate has to confirm the president's appointments. What happens if the Senate's not there? What happens if they've gone home for the summer and they're back in their constituencies? Or they're at wherever they go on the summer vacations. I don't know where they go. What happens then? Does it mean the president just can't appoint anybody to anything? That doesn't make any sense. That's really no way to run a government. So we have the recess appointments clause that says, roughly, when the Senate is in recess, the president can make an appointment. The difference is, instead of the appointment being permanent, either in the case of a judge, a life tenured appointment during good behavior. In the case of an executive branch official, the person stays in office until the president discharges him, or until some of the executive branch officials have terms. Instead of that, what happens with the recess appointment is the person stays in that position for sort of a year plus, until the end of the next session of the Senate, at which time they're no longer in that job. So the trade-off is a president can make these appointments when the Senate is in recess without senatorial confirmation, but he doesn't get to make a full-term appointment. It's an appointment that's going to come to an end sooner than it otherwise would. Now, here is what gave rise to the litigation in the Supreme Court, to the case in the Supreme Court now. The Senate has done this trick a couple of times. It did it in the George W. Bush administration, and it's now done it again in the Obama administration. And the trick is they stage what they call, and they actually call it that, this is language from a Senate resolution itself, pro forma sessions. So here's the idea. The Senate wants to take a break. They want to go home or go in their constituencies or be away from Washington. But they don't want the president to be able to make recess appointments. So what they do is they say every 3 days, a senator will come into the chamber, bang the gavel, say the Senate is now in session, bang the gavel again, say the Senate is now adjourned. And the idea is basically no one thinks 3 days is a long enough period for the president to count as a recess. So if they keep having these sessions, quote unquote, every 3 days, the president can't make a recess appointment. That's the idea. And they'll keep doing these 3-day things for as long as they want to be out of session. And then at some point, they'll have a real session of the Senate. But they will supposedly have broken up a 3 or 4, in this case, it was the case that gave rise to the litigation. It was about a 5-week recess. They will have broken it up supposedly into these 3-day segments. And as I said, no one thinks that 3 days is long enough to count as a recess for complicated reasons that we don't, don't bear on anything we need to get into. By the way, if you're speaking of complicated things about the Constitution, if you're thinking about just the politics of this, why is the Senate, which is after all controlled these days by the Democrats, doing this to a Democratic president. It was easy to see why in the George W. Bush administration, when the Senate was controlled by Democrats, they would do it to a Republican president, which they did. What about this? There's a provision in the Constitution that says neither house of Congress can adjourn for more than 3 days without the consent of the other. So what happened is the House said, we're not going to adjourn for more than 3 days. And that kept the Senate from adjourning for more than 3 days. I think what's going on with that original provision, and it tells you something about the different world that the framers of the Constitution lived in. They really did sort of think there might be a problem if the House of Representatives wants to prevent anything from happening, so they just leave. Meanwhile, the Senate wants to get going. So they put in this provision to prevent that from happening. Now, neither House of Congress can adjourn without the consent of the other for more than 3 days. So the House essentially compelled the Senate to have these pro forma sessions at 3-day intervals. And you see what the resolution says. It says a pro forma session and no business will be conducted. It's as explicit as you can be that we're just doing this in order to prevent the president from making recess appointments. There's no question about what's going on here. As I said, this is not new with the current president. It was done in the previous administration as well. I believe that was the first time it was done. Now, President Obama took the position that these pro forma sessions don't count and that the recess, for purposes of the recess appointment, is the time between real sessions, which, as I said, in this case was about 5 weeks. And he was just not, they say no business is going to be done. I'm not going to count this as these pro forma sessions as interrupting the 5-week-long break. As far as I'm concerned, this break lasted 5 weeks. I'm going to make some appointments during that break. That's what President Obama said. Some of the appointments he made were to the National Labor Relations Board, which, as you know, adjudicates charges of unfair labor practices against employers and unions. The National Labor Relations Board, with appointees who were appointed in this, with members who were appointed in this way, found that an employer had engaged in unfair labor practice, imposed sanctions on the employer. The employer appealed, saying that ruling is invalid because these people were not properly appointed. They were appointed during a recess, but there was no recess. They weren't confirmed by the Senate. Therefore, the board didn't have the power to impose these sanctions. That was what set the stage for the litigation. And everybody thought the litigation would be over this question, and it's a fairly disputable question. Even President Obama's lawyers, when they gave him advice that he could make these appointments, they admitted this is a disputable question. Whether these pro forma sessions really do count as sessions of the Senate interrupting the recess, or whether a president can say, no, this is phony, the recess is 5 weeks long. Everyone thought that would be the issue in the case. It is an issue in the case, but the case in the District of Columbia Circuit took quite a different turn. What the District of Columbia Circuit said was, you have to read this very closely. What it says is, the president shall have power to fill up vacancies that may happen. The first thing they said, during the recess of the Senate. And the District of Columbia Circuit said, the recess of the Senate. Now, what does that mean? It doesn't say a recess of the Senate. This is what the opinion says. You can go look it up, as they say. The recess of the Senate. They must have had in mind, the District of Columbia Circuit said, that there was only one recess that counted. And they said, you know, the way the Senate works is the Senate stays in session for 2 years, then there's another election. And then 1/3 of the Senate is new. And the Senate comes back in, and it's the third of the Senate and the entire House is new, and that's a new session. And the court said, the lower court said, that's the only recess that counts, is the recess that occurs in between those sessions. Between when one Senate, having been elected, leaves office, and another Senate comes into office. The new Senate comes into office, that's by the Constitution requires it to come into office on January 3rd, unless they provide otherwise by law. So the recess occurs between whenever the Senate bangs the gavel before January 3rd and January 3rd. That is the recess, they said. That's the only recess. So the president has to make, if the president wants to use this clause, he's got to do it during that recess. In case you're wondering how long that recess is, sometimes it's a few weeks. They adjourn for the December holidays and don't come back until January 3rd. Recently, you want to know how long that recess has been? Shorter than that. What happens is they will meet, they will not recess, They'll meet on January 3rd. The old session is over. The new session has begun. Now, if the president could slip in a nomination while the gavel was in the air, he could conform with the District of Columbia Circuit's ruling. But that's not that easy to do. That was one thing they said. It's got to be during the recess of the Senate. Here's what else they said. Let's go back to the clause. The power to fill up vacancies that may happen. Vacancies that may happen during the Senate, during the recess of the Senate. The lower court, the DC Circuit, said, well, as we read that, it says the vacancy has to begin during the recess. Vacancies that may happen during the recess. So that means if a job has become vacant while the Senate is in session, but the president doesn't get around to filling it until a recess, nothing doing. The vacancy has to begin during the recess. Now, of course, what makes this controversial is not that there's a vacancy, the president doesn't get around to paying attention to it until the recess. What makes this controversial is the president will nominate someone for the vacancy, the Senate will refuse to confirm him, and then at that point the president says, okay, as soon as you guys go out on recess, I'm going to recess appoint that person. And I'll only have him in office for the year plus, but that's better than nothing. And this is a way of getting the Senate to pay attention to the nominees, and you know, maybe we can talk now. I mean, if you don't like this person, maybe I can put up someone you like better, and you'll confirm. But if you persist in refusing to vote on my nominees, I'm going to recess appoint them, and they'll be in office and they'll be exercising power for a year plus, and that's the price you're going to pay for ignoring my nominees. This makes that essentially impossible. That allocation of power, essentially impossible. Now you might say, and you certainly could plausibly say, well, that's not a crazy reading of that language. Neither of these things is crazy. It does say the recess, and vacancies that may happen during. I mean, you could read that to say the vacancy has to occur for the first time during the recess. That's not a crazy way to view that language, and it's not. And that's really the point. So what's wrong with the DC Circuit's opinion? Yeah, it shifts some power from the president to Congress, but I mean, maybe that's the right allocation of power, and maybe the recess appointments clause should just be used when someone leaves office, dies, or resigns during a vacancy, and you don't want the job to stay open, and maybe that's the proper use, and maybe it is. But here's the problem with that. Here's one problem with that. That guy, you know that guy, it's an old guy, right? That is William Wirt. He was the Attorney General for James Monroe. And William Wirt, when he was Attorney General for James Monroe, wrote an opinion that said, no, the vacancy doesn't have to come up during the recess. Any vacancy that is still there during a recess, you can fill it with a recess appointment. That has been the understanding of the executive branch and Congress for, well, since the Monroe administration, about 200 years. That's been the understanding. I'll talk about that guy in a second. Here's what's happened to with appointments made to vacancies that did not occur during the recess, the things that the DC Circuit said you can't do. Every president since President Buchanan, 35 presidents at least, have made appointments that the DC Circuit now says were unconstitutional. Even that reading of the language is plausible, but here's what's actually happened. That included all of those characters, the Supreme Court Justice, Solicitor General, and so on. Every one of those presidents has made an appointment that the DC Circuit now says would have been invalid. Now, that doesn't mean that we're going to go back and find out the votes cast by Justice Davis and try to overturn those cases. That's not that crazy. But that would be crazy. But what it does tell you is that there was a well-established understanding between the president and Congress that it didn't matter when the vacancy arose. If the vacancy was still there during the recess, the president could fill it. The Attorney General asserted that. Presidents made those appointments. Congress didn't rebel. Congress paid these people salaries. There are actually various times in which Congress set up a committee to say, what does this recess appointments clause mean? The committee agreed with Attorney General Wirt. Since we're speaking of him, there he is. And this was a settled understanding. The D.C. Circuit quarreled a little bit with how settled it was, but the evidence is very one-sided, that this was a very settled understanding. Okay, so who's the other guy? That's Attorney General Daugherty. It was Wilson's Attorney General. And you can guess what he did. He issued an opinion saying the opposite of what the D.C. Circuit said about the recess issue. He said, no, the recess means any time the Senate breaks for a substantial period of time. 10 days, probably not enough. 20 days, definitely not enough. Remember I said 3 days no one thinks is enough. 10 days, definitely enough, probably enough. 20 days, definitely, certainly enough. Any substantial break counts as the recess for purposes of the Recess Appointments Clause. So that was about 100 years ago. And if that understanding, Attorney General Daugherty's understanding, that guy's understanding, if that's wrong, then here are the appointments that should not have been made. Over 600 civilian appointments, thousands of military appointments. The Appointments Clause applies to high-ranking officers in the military as well. And presidents routinely use the recess appointments power, especially in wartime, to fill those jobs. And those appointments would have been invalid too. The reason these numbers are approximate, by the way, is also part of the story. Because these understandings were so well settled, the vacancy doesn't have to arise during the recess, and that any recess works. It doesn't have to be the one between the sessions. Those were so well settled that no one was keeping track. So what's happened is in the litigation, the government has gone back and tried to reconstruct records, but the records are difficult to work with because no one thought it mattered whether the recess, whether this was an intercession recess or not. And no one thought it mattered when the vacancy arose. So you've got to do a lot of digging even to come up with an approximate number. So what I want to say is that it seems to me it doesn't make much sense to say, well, here's something we've been doing for 100 years at least in one case, 200 years at least in the other case. Seems to work well enough. Congress has lived with it. The president's lived with it. President counts on it. You have all these people appointed under it. But, you know, we, the D.C. Circuit, have gone back and we looked we did a kind of literary theory style close reading of this clause. And no, we think that practice is all wrong. I don't think that's a good way to run a system. I'm being a little bit unfair to the D.C. Circuit because it did, as I say, have its own view about the history and said the history is more unequivocal than I am portraying it to be. But the history at least is one-sided, even if it is not absolutely monochromatic, is at least one-sided. And the record of congressional acquiescence in this practice by the president is very strong. And it seems to me to toss all that out to say that this vestment that has accommodated itself to us, that sort of has grown with our country and that we've come to accept, you know, we're going to toss it aside because 200 plus years ago there was a generation that made a contrary decision, even if they did make that decision. Seems to me that's not a sensible way to run a country. But you may think otherwise, and that's fine. Well, it's actually not fine. And here's why it's not fine. If you're tempted by this kind of fundamentalism, here's what you're getting into. Established churches, meaning the government has an official church, it's the official state church and supported by tax revenues, okay? We don't have those in this country. The states can't establish churches, the federal government can't have an established church. I mean, you know, there's one in the United Kingdom, there are established churches in the UK and England and Scotland and Wales, and you know, those are great places to live, really. So it's not like it's a horrible thing, but we don't have them in this country. But there's the clause, Congress shall make no law respecting an establishment of religion. It doesn't say Congress shall make no law establishing a religion. It says respecting the establishment. What's going on with that? When that was drafted, this is actually quite clear. They didn't want Congress either establishing a religion or preventing states from establishing religions. Congregationalism was an established religion in Massachusetts at the time. And when that clause was drafted, the framers didn't want Congress telling Massachusetts it could not have an established religion. So if you're going back to the language, you have to explain why it's not okay today for a state to say, no, in this state the established religion shall be. You got to explain why that's so. If you're, if you want to rely on tradition and history, you have plenty on your side. There haven't been established churches in this country since the 1830s. But if you're relying on the text, you have a problem. Got some other problems too. I'll just give you a couple. There are lots of them. What about that the? Since we're talking about thes, what about that the? Did you know that the was there? You knew the First Amendment was about freedom of speech, right? Did you know it was about the freedom of speech? I bet you didn't. What's the significance of that the? Never underestimate the significance of a the. Here's the argument. This would be a plausible argument on the basis of the text. At the time they wrote the First Amendment, they didn't mean some free-floating idea of free expression. What they meant was there was an understanding in English law at the time of what the freedom of speech was. They had some ideas in England about what the freedom of speech was, and the framers meant to carry over those ideas, period, the end. They didn't mean to authorize later generations to say, oh, it allows you to advocate violence, it allows you to engage in hate speech, it allows you to defame public officials. No, no, no. They meant something very specific. The specific thing they meant was you couldn't stop people from speaking ahead of time. They didn't mean you couldn't punish them. Pretty clear, not 100% clear, but pretty clear that the understanding in England was you couldn't engage in what were so-called prior restraints, keep people from speaking, but if they spoke, you could throw them in jail. And remember, by the way, the people who wrote that language, many of them voted for the Alien Sedition Acts, which did allow the government to throw its political opponents in jail. So you got another problem with that the. Why doesn't that mean, just as the recess means, no, 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 not just any old recess, the freedom of speech doesn't mean what we think of as the great freedom of speech. It means, no, 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 something very specific. Okay, I'll just give you one more. There, as I said, there are several I could point to. What about that? Can the federal government discriminate against people on the basis of race? Of course not, you say. Show me the constitutional provision. Well, the Equal Protection Clause, you say, that's the provision that forbids discrimination on the basis of race. Have a look. You see anything about the federal government in that clause? I don't. No state shall deny people equal protection. It doesn't say the federal government shall not deny equal protection. That provision was drafted, of course, in the wake of the Civil War. So if you're tempted to say, well, they said state, but surely they meant federal government. What, because in the wake of the Civil War, they didn't understand the difference between states and the federal government? Like blue and gray? When they said state, you have to assume they meant state. Now, of course, it is well settled, been well settled since the great case of Brown against Board of Education, actually the companion case to that case, which involved the District of Columbia, that the federal government cannot discriminate on the basis of race. But you don't get that out of the Equal Protection Clause. The Supreme Court got it out of another clause that really doesn't make a lot of sense. Does it matter that it makes a lot of sense? I don't think so. I don't think so. I think the dynamic in this country since the Civil War, and certainly since the Civil Rights Revolution, is we're not going to allow discrimination on the basis of race. That was the clothing that eventually happily came to fit us in Burke's terms. And to even entertain the idea that we would go back and say, but I don't see it in the Constitution. Where is it? I think is alien to our constitutional traditions. I think that's alien to the way we do constitutional law in this country, and I think it should be. So let me just sort of say a couple of words in summary about this. I think this reliance on the text, let's go back to what I called fundamentalism, let's go back to the beginning, let's go back to the founding, let's go back to where things started. It passes itself off as a kind of small c conservatism, as a way of getting in touch with our history. I don't think it's that at all. I think it's the opposite. I think it's the opposite. I think it's deeply radical in the sense of trying to rip things out by the roots. I think when you don't like the traditions that a country has, in Burke's terms, grown up with, when you don't like them, then you say, well, I'm going to discover something in our original principles that can cause us to reject those traditions. And I think what you're faced with when you hear the fundamentalist appeal, and this can come from either side of the political spectrum, is a dissatisfaction with the law that's developed. The dissatisfaction can be so-called liberals dissatisfied with a conservative tradition. It can be so-called conservatives dissatisfied with a liberal tradition. But that's what you're getting, is people who don't like the understandings that have built up over the years. I don't think that's American law. I'm pretty confident it's not the way our constitutional system works. And I also want to say that it doesn't seem to me to be a good way for a constitutional system to work. You know, we've learned some stuff over the years. We've figured some stuff out that they didn't know back then. Either they didn't know because it was a different world, or they didn't know because, you know, we have a couple generations more experience and enlightenment to draw on, and we figured some stuff out, and we've learned some lessons, and maybe we've even developed a little bit as human beings in the intervening time. And I don't, for myself, speaking just for myself, understand why you would want to throw that away and go back to the supposed lessons of the founding period. So thank you very much. We have time for some questions. Oh, I was warned not to press that button, but there you have it. Anyway, why don't I do questions instead of standing up here clicking this infernal thing? Sir.
What about deference to the legislative branch in terms of its rules? So if the Senate at one time allows us to change its rules about what time to recess, don't we owe some deference to the Senate or Congress and how they define their own rules of procedure? Doesn't that make a difference? So if, for example, 20 years ago, Congress was quite happy to let presidents make recess appointments, they didn't care, that was fine with them, but now modern Congress doesn't want to do that. What about deference to the legislative branch?
Yeah, the question is what roles does the deference to the legislative branch play in this, and what if the legislature says, look, we used to regard a recess as being this, now we've changed our minds about that. I think my view about that would be, you know, that's something that can be taken into account. I mean, if there's a change in the understanding, if the understanding between the branches seems to be moving in a certain direction, that doesn't have to be ignored. There's still, you know, we're interpreting the Constitution, and it's not as if what the legislature says is going to, by itself, going to conclude that question, any more than if a president came along about some other constitutional provision and said, oh, well, all these years it's been understood that, you know, there's certain things I can't do without congressional authorization, but I now want to assert the power to do it. We wouldn't simply defer to that. We'd say, well, okay, we'll take that into account, but if the tradition is solid, you can't overturn it. So yes, if there were a consistent legislative practice of rejecting a certain interpretation of the recess appointments clause, yeah, I have no problem with saying that should play a role. I wouldn't yet put the pro forma business in that category. It's not crazy to say at some point, and maybe we're at that point, the pro forma exception qualifies for that. I don't think that's an implausible view. And as I said, President Obama's lawyers went out of their way to say it's not totally clear that you have the authority to disregard these pro forma sessions. So I think that's a reasonably disputable question. What I am reacting against is the idea we don't need to pay any attention to these evolving understandings. We got the answer in the text, the Constitution. Sir.
Don't we have a problem with chat?
With the legislative veto. The question was, do we have a problem with chata? Chata was the case that declared unconstitutional a thing called the legislative veto. It was a provision found in many statutes that allowed not Congress, but either a House of Congress, sometimes a committee of Congress, or sometimes the two houses of Congress acting together but without the president's agreement, allowed them to overturn something the president did. So an agency would issue a regulation. The regulation was authorized by law, but then a House of Congress would come along later and say, no, we don't like that regulation. We want to veto it. Was that okay? Supreme Court said, no, that's not. If Congress wants to do something, it's got to do something in the regular way, both houses of Congress, presidential signature. It's a very important question. The argument would be, look, there were lots of legislative vetoes. They went on for a long time. Why isn't that an example of this sort of settled tradition that I like so much? And the Supreme Court am I saying the Supreme Court was wrong to say that was inconsistent with the Constitution? Chata is a different case for the following reason, I think. If you look at the history of the legislative veto, presidents, and this is presidents of both parties for a long time, consistently took the position that's unconstitutional. Now, they usually went along with it. If the legislature, quote, vetoed something, the president would usually stop doing it. But they, I think, invariably said, we don't have to stop doing it, we're just stopping doing it because we don't want to make a fuss. We think it's unconstitutional. And that's how I would distinguish those. I do think in a case like that, the fact that this is a long-standing practice should count for something. I think that's right. It's just that when the president consistently disagrees, it's not like this where you have Congress consistently agreeing. That's the distinction I make. Sir.
You mentioned some Attorney General opinions. This is the first time that the Supreme Court, that a court has actually weighed in on the constitutional aspect of this provision. Is that correct?
First time the Supreme Court has, yes.
Okay, it has not been. So, I guess my question is, in the Constitution, it says that that's the supreme law of the land. So, that to me says that the Constitution's wording, not traditions or practices, is the supreme law. And a lot of the issues that you brought up have been ruled on before by the court. So, before there has been judicial interpretation, how much credence can you really give tradition because it hasn't been ruled on before?
Well, I don't, I mean, let me ask you a question back. Why are you paying any, if you think that that language in the Supremacy Clause settles the, makes the text supreme, why are you paying attention to court decisions?
Well, the court, I guess, interprets what those words mean. So in this case, the court has yet to interpret what those words mean.
Great, great, and there's your answer. We've got to interpret what the words mean. And what I want to say is you could interpret them by looking at judicial precedent. You can interpret them by looking at other things. Because after all, put yourself in the shoes of the court in this case. It's going to have to interpret those words. There are no previous Supreme Court decisions. It's going to have to look at something. What's it going to look at? Well, one of the things it is in fact going to look at, and I say one of the things it ought to look at, is what you might think of as non-judicial precedent. Precedents created not because someone brought a lawsuit, but precedents created without a lawsuit. The President and Congress have been doing this forever. No one even thought to sue. And that tells us something. And that's what I would say. I would put those in line with judicial precedent. But terrific question, I think. Yes, sir, next to the gentleman who just spoke.
My argument is actually kind of similar to his in that I understand your point about uprooting the free speech based on the contextual interpretation.
Yeah, yeah.
It would be like hugely
Crazy,
disruptive toward
right?
like everything this country has decided about that.
Right.
But could the argument be made that in this issue it would be fairly unintrusive to go to the constitutional interpretation?
Oh, that's, I mean, a nice question. So the question is, look, it's one thing if you're talking about like big, morally loaded issues, free speech, racial discrimination, establishment of religion. I mean, those are things where, you know, if we've arrived at a certain understanding, you really don't want to uproot it. But the question is, but, you know, if you're dealing with something kind of technical, you know, just read the words, and that should be enough. I get that. I think that's an important point. I think there are provisions in the Constitution where you really want to say, you know, I mean, all right, it says that the president has to be 35 years old. You know, that was drafted for a time when people's life expectancies were much shorter. Now that age really should be higher than that. So let's interpret 35 to be 35 Jupiter years. Or something like that. No one would ever do that. No one would ever do that, right? Even though we do stuff, you know, kind of like that elsewhere in the Constitution. And the reason you wouldn't do that is you say, you know, what's the problem? It's, you know, who cares? 35, maybe it's a little too low nowadays. You know, it's not a problem. I get that. So I think part of what I want to say is that this issue has become highly controversial and become really an issue about the distribution of power between the president and Congress. It's not just, as some things are, kind of a technicality. You want to get it settled, let's get it out of the way and move on. That the president's ability to make recess appointments really is an important, I hate to use the word weapon, but that's probably the right word, for him to use against the Congress that blocks his, is blocking his appointments. So it has become an important question. And when something becomes an important question, I agree with you, it is not as morally laden as free speech or race discrimination, but it's pretty important if the president can't implement his programs because Congress won't confirm his appointees. It's pretty important. And when you're dealing with issues like that, we can't just say, you know, maybe the text is silly, but it gives us an answer, let's move on. So I get the general point that we want to make this distinction, but I would want to say that this issue falls on one side of on the same side as the things where you would agree that tradition should be taken into account. Sir.
What is your expectation of how the Supreme Court is going to analyze this question?
Question is what I think the Supreme Court's going to do. It's tricky. I think the temptation for the court will be to rule against the president on the specific issue about pro forma appointments and to say we don't need to get into this other stuff because these appointments were not valid because they were made during this pro forma session or during a recess that was interrupted by pro forma sessions. So they're not valid. And we don't need to decide whether only the recess and whether the appointments have to rise before. Now, the problem with that, and this is something that came up in the briefing that the federal government was very concerned about, the problem with that is then you still have this D.C. Circuit opinion hanging out there, drawing into question all these other, the president's ability to make these other appointments. So I think that sort of ruling, which will be tempting to the court, you resolve this one issue, which everyone agrees is a reasonably disputable issue, resolve that against the president, you don't have to get into the other stuff. Very tempting for them. But it really does create a situation that's untenable for the executive branch. So I don't know if they will see that or if the government will make them see that and they'll resist that, that temptation. I don't think they will do what the D.C. Circuit did and uproot all this well-established stuff. I don't think they'll do that. But I've been wrong before, including in cases I argued. So I don't. That opinion, you know, will get you the proverbial cup of coffee with a $3.75 at Starbucks.
Will you think it'll be a 5-4 decision?
Not necessarily. I could see some kind of middle ground thing attracting unanimity or near unanimity. I could see that happening. Sir, or do we have to break? A couple more questions? Sir.
Rather than reading in kind of a limited interpretation of that clause, why not just expand the political questions doctrine to these kind of separation of powers games? And then you don't have to have a reading, whether that be right or wrong, and just say, let the President and Congress fight this thing out.
Yes, you could. So the question is, why not declare these issues to be quote-unquote political questions, which, as you know, is a term of art the Supreme Court uses, meaning there is an issue here, there's a constitutional issue here, we are simply not going to resolve it. This is just not an issue for the courts. A classic example would be the legality of a deployment of military forces, which the Supreme Court just says we're not going to get into whether it was legal to send, to engage in military activity in Libya. They haven't said that, but they would. We're just not going to get into that. Not going to decide it one way or another. Why wouldn't they say that about this? I guess they could. It doesn't have the same feel as a political question because complaints about appointments, about the validity of appointments, come up in other ways. The appointments clause, I don't know if I quoted the relevant part. No, I didn't quote the relevant part, but there's an issue about whether certain appointments can be made by members of Congress, can be made without Senate confirmation, and they decide those questions. And this looks a lot like those. So I think it'll be tough for them to say it's a political question. It might be a nice way out of the box, but I don't see them taking it. Sir, in the back row.
If a pro forma appointment is made and the Supreme Court determines that it's illegal, will any decision by that appointment be considered void ab initio?
Well, like all the other questions, terrific question. The question is, well, okay, supposing the Supreme Court says one of these appointments, to say a board or an agency was an illegal appointment, what happens to the decisions made by that board or agency while the illegal appointee was on the board? Are all those decisions wiped out? It could be hundreds, maybe even thousands of decisions, depending on what agency you're talking about. Maybe. There is this doctrine, this doctrine floating around the law, which you kind of knew it had to be there just to avoid this problem. It's called the de facto officer doctrine. And what the Supreme Court has done on a couple of occasions when they have said, for example, this category of appointments is invalid, or this body didn't have the authority to decide this kind of case after it had decided, a million cases like that, they'll say, but, let's water over the dam or under the bridge, whatever cliche they're minded to have, or over the bridge or under the dam. They'll say, we're not going to disturb things that have gone on in the past. That's just too disruptive. And it's just made up just to deal with this thing. But it has a name, it's de facto officer. It's got some Latin in the name, so it kind of sounds like something that wasn't made up, And it does, of course, make a lot of sense that if you have this thing where it's reasonably disputable, and it's not obvious that anyone was really treated unfairly. It's not like a case in which someone was denied due process or discriminated against. It's a relatively, it's a sort of thing where you can't even be sure that the decision would have been different, that they'll say, well, the ones that are in the past are in the past, but in the future. And my guess is if they do decide this case on a basis that invalidates large numbers of appointments, they will invoke the de facto officer doctrine in order to avoid just that problem.
Taft Lecture is a highlight of our year every year, and you can see why. I want to ask you all to join me.
Thank you. Thank you. Thanks. Thanks a lot. Thanks.